Welcome to this presentation relating to Chapter 2 of our textbook. We're going to cover the first portion of the first PowerPoint, relating to the informal fact gathering and investigation process. We're still in the early days of our lawsuit. In fact, we don't even have a lawsuit at this point. And many of these steps we'll be looking at are things that probably it's more likely that the plaintiff side will be doing rather than the defense side, because of course at this time it may be that the defense doesn't even know that it's about to be sued, or if it does suspect it, it may not be interested at this point in investing a lot of resources, because after all it's just a possibility, not something that it's certain about. Of course, there are other fact patterns in which the defense is very well aware of the lawsuit and knows that it's definitely coming. Under those circumstances, the defense side might be as involved in pre-lawsuit activities as the plaintiff side. But even if the defense side hasn't geared up yet or isn't going to gear up yet at this point, at some later point in the litigation, the defense side will have to be considering the exact same issues that we're talking about now. That time period just might occur after the lawsuit's been filed, but again, whenever it happens, this type of analysis is going to be helpful. So let's get started. So the first thing we're going to think about is the issue of Rule 11. Rule 11 is really the first Federal Rule of Civil Procedure that we're going to talk about. It's one of the most important rules of civil procedure. It's certainly one of the rules that is most on the minds of attorneys and paralegals, because it is a rule that relates to the law firm. Most of the rules relate to the parties. The rules say what the plaintiff can do, what the defendant can do, what the witnesses can do, those types of things. But this particular rule is set up to tell the attorneys in the case what they can do and what the penalties might be if they don't do what they're supposed to do. And so this is the area that attorneys see a great deal of self-interest in making sure that there is compliance. Rule 11 has been around for many, many years, and it has been a source of some controversy over that time. It's a pretty strong stick to wave at attorneys, and for attorneys to be aware of it as they proceed. And so when one is gearing up to either file a lawsuit or to answer a lawsuit, these thoughts ought to be foremost in the minds of the legal professionals working on it, both for the benefit of your client, but also for the benefit of your law firm and, frankly, your career. So let's look at what Rule 11 says. Well, first of all, let's give a little background. Rule 11 is about looking at the signature on legal documents in a bit of a different way. If I were to write you a letter, probably at the end, maybe after very truly yours or sincerely, I would write my name. And what that usually, I guess, means when the name is put on it is it means, hey, I wrote this letter. This is from me. It's not from somebody else. It's a way to kind of authenticate the letter or to confirm that it is from this person. A signature, which is oftentimes called a subscription, in a lawsuit scenario is a little bit different, in fact, quite a bit different. By the way, let me go ahead and put this on a slideshow. Here we go. Because what the attorney is doing when he or she signs the pleading isn't simply saying, yep, our law firm prepared this. Yep, this is the real document that we're really submitting. Instead, the attorney is vouching for the contents. He's saying, my good name, my career, my reputation, my assets are at risk based upon the things that I said in this letter, or not this letter, this document that I'm filing. It's a big deal to sign a pleading. And so one needs to approach it with a certain level of caution when one does it. That's one of the reasons why you have to be an attorney licensed in that court in order to sign pleadings in a particular court matter. For example, I have been admitted to two federal district courts, the Southern District and the Northern District. But I've never been admitted to a district court, say, in Montana. So even though I'm a licensed attorney, I would not be eligible to practice in that federal court. Similarly, I've never been admitted to the Western District of Texas. So even though I'm admitted to practice in state courts in Texas, I would not be eligible to practice in the Western District of Texas. It wouldn't be a big deal or a difficulty for me to become a member of those bars, but I would have to before I could practice before those courts. Um, and of course, if I were not an attorney, I wouldn't be eligible to sign the pleadings until I, again, went to law school, passed the bar, did all those particular things. If an attorney is unable or unwilling to sign a particular document, it is true that the client can sign the document. So that's an alternative position. Of course, when the client signs a document, the client is making the same types of statements about his or her case that the attorney would have been making if the attorney had signed the document himself or herself. So if there's factual misstatements in the document, then that a party who may or may not be an attorney is facing the possibility of some serious sanctions. As a result of Rule 11, attorneys want to, or really have to, investigate the claims before they even file the lawsuit or respond to filings of the other side. You can't just say, well, if these facts were true, that'd be good for us, so we're just going to assume they are true. That's the road to Rule 11 sanctions. So let's get started on exactly what Rule 11 says. This is the actual language from the rule. Of course, you can look the rules up yourself. They will be, of course, in the textbook, but you can also find them at law.cornell.edu. You can find all the federal rules of civil procedure there. Now, there's other places you can find them as well. In fact, you could just type in this title right here, Federal Rule of Civil Procedure 11, and find it in lots and lots of different resources. But you don't need to, because we have the rule right here. Let's first of all look at the first part of that rule. The first part of the rule is entitled Signature. It says every pleading, written motion, and other paper that must be signed by at least one attorney of record, in the attorney's name or by a party personally if the party is unrepresented. So everything that goes into the court, into a file for this particular case that is submitted by one side or the other has to be signed by the attorney or by the party. So that's the standard. That's the first point. You can't just say, well, we're not sure if this is true, so we're not going to sign it. That's not an option. Let's go to the next slide. Okay, so let's look at a part. This is section B. When we were here, we were at section A. We've skipped over a little bit of it. So we're going to go to section B2 of the rule. The claims, defenses, and other legal contentions are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law or for establishing new law. This is what you would call the theory of the case. What is your theory of why you, if you're representing the plaintiff, you ought to be successful? Let me give you an example of existing law. We're going to talk about this example later on, so it's kind of a useful one to get started with. Currently, the law, I think probably in all of the states in the United States that use common law, to establish negligence is a four-element process. You have to find a duty, you have to find a breach of the duty, you have to find that that breach caused damages. So those are the four elements. And so your legal theory would be in that situation, those four elements of negligence. That's well established. So in that case, if that is your legal theory, you're going to be in good shape. But let's say that you wanted to advance another theory. You want to establish that, you want to suggest an alternative set of elements for negligence. Let's say you were going to establish that there was a duty of care and that there were damages. But you don't want there to be the legal requirement that there be a breach of the duty, and you don't want there to be a requirement that that breach proximately caused the damages. So you want to remove the middle two elements. So you are suggesting a change in existing law. Well, then you'd have to consider, okay, so I'm not going to fit into this first category, warranted by existing law. That's not going to be an option. So I have to see whether my plan is going to fit into this next category. A non-frivolous argument for extending, modifying, or reversing existing law. I will call that modifying, possibly reversing existing law. The problem I'd have, though, is that that sounds like a very frivolous approach. Wait a second, you establish that Bob owes a duty to Mary and that Mary is injured, but you don't have to prove that Bob violated that duty? So let's imagine, let me show you how that might play out. Bob is driving a car, Mary is driving another car. They're on the roads together. The law has well established that Bob owes Mary a duty of care, just like Mary owes Bob a duty of care to be safe on the roads. Mary falls asleep behind the wheel of the car, and she is in a car accident. She's badly injured. The car is badly injured. Bob had nothing to do with Mary falling asleep, had nothing to do with the accident. Certainly, as a result of Mary falling asleep and being in the accident, she had damages. So we have proved two of those four elements. We've proved that Bob owed a duty, and we've proved that Mary was injured. If Mary could then sue Bob because she has two of those elements, really, Mary could sue anybody, right? Because Bob did in no way cause that action. So it seems to me that really no court would consider accepting that argument. They want to have Bob doing something unwise or incorrect or dangerous before they're going to find Bob is responsible for Mary's injuries. So I would say that that suggestion would be a frivolous argument for extending the law. That legal theory would not float, and so we would be in violation of Rule 11 by submitting that in the papers that we were going to file. So we would recommend that you not do that, obviously. Let's go to the next part of Rule 11. Now we're looking at the B3, so this is directly below where we were before. In the B2 section, we were talking about the legal theory. Now we're going to talk about the facts. Let's assume that in our case, it's still Mary suing Bob, but this time, Mary's okay. We're representing Mary. Mary's okay with the normal definition of negligence. She's okay with the idea that she's going to have to show that Bob owed her a duty of care, that Bob breached that duty of care, that Bob's breach proximately caused, and then the fourth element being Mary's damages. So we're okay with B2, but what we're concerned about now is the facts that we're going to use to support those four elements. And so this is the part of the rule that we would be interested in examining to make sure that we aren't going to be in violation of Rule 11 by submitting our pleadings with some factual allegations that may not be appropriate. Okay, so here's the rule that we're looking at now. My mouse, here we go. The factual contentions have evidentiary support, or if specifically so identified, will likely have that evidentiary support after a reasonable opportunity for further investigation or discovery. Okay, well, let's first of all consider the first aspect. The factual contentions have evidentiary support. Let's imagine that it's Mary's opinion that Bob has the power to mind control her. And so while she was driving, Bob was in a different car, and he was able to, just through his thoughts, send a message to her brain that made her sleepy and caused her to fall asleep behind the wheel of the car and thus being injured. Okay, well, if that is a true contention, then yes, we have satisfied the four elements. Bob owed Mary a duty of care. Bob breached it by sending those thought waves that were going to cause Mary to become injured. They proximately cause the injury because common sense says if you do something that's going to make the driver sleepy while the driver is driving, that is very likely to cause injury because the driver falls asleep and there's an accident. So yes, we have satisfied that, but the problem isn't so much that fact, if proven, would support the four elements that we need to prove. The problem is there evidentiary support for Bob to be able to mind control Mary in that way? Not aware of any technology that would allow Bob to do that, and so the court would very likely say, well, where's the evidentiary support for Bob having this ability? And if you didn't have anything to show that there's the possibility of that, then I think the court very likely would say this is a Rule 11 sanction situation. Okay, let's look at the second category. Let's say that we have another set of allegations here, and we're trying to see if it's going to fit into this category. will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. Let's think about that for a second. Keep in mind, from the plaintiff's perspective, there hasn't been any formal discovery. The only information that the plaintiff has to work from is the information that he or she has ready access to. In other words, the defendant hasn't been under any requirement to provide any information to the plaintiff. And sometimes in these cases, only the defendant has enough information to really connect all the dots and make sense of the story. Let me present another fact pattern. Let's imagine this time that Mary is wanting to sue her former doctor. We'll call him Dr. Bob. Mary went in for surgery. Dr. Bob performed the surgery. And after the surgery, Mary just never felt right. She felt that something went awry during the surgery. She was asleep during the surgery, so she doesn't know exactly what happened. Dr. Bob never told her that there was any kind of mishap or any problem. In fact, he denied there was any problem. And yet Mary has felt significantly worse after the surgery. So as a result, she doesn't really know what happened. And she's not really going to know until she files her lawsuit and is able to proceed with discovery. So when she makes statements in her draft lawsuit that she's going to file with the court, she's going to have to admit kind of, hey, I'm not sure what happened, but what I do know is I felt okay before the surgery, and ever since then I felt bad. And so it is my theory that something likely went awry during the surgery, and once I get access to discovery, I'm going to be able to prove that with the evidence that I get. In that scenario, Mary's probably okay because she's done everything she can to find out that information, but she can't get access to the real data that she needs for this purpose. And so her argument is probably going to fly because, number one, she's tried to find what she can, and it's very possible that there is something available to her in those files. So we have to consider the legal theory. Is that reasonable under the circumstances? We also have to consider the facts that we're going to allege. Are those reasonable? Either one of those two areas, if they aren't reasonable, can result in Rule 11 sanctions. Let's go to the next slide. Okay, and this is B4. Denials of factual conditions are warranted on the evidence or, if specifically so identified, are reasonably based on belief or a lack of information. Let's imagine for a second that we are now representing Dr. Bob. And Dr. Bob is responding to the lawsuit that Mary has filed. And in Mary's initial lawsuit, she contended that she was a woman. Well, Dr. Bob performed surgery on her, and during the scope of the surgery, he had the opportunity to examine her. And so he actually knows that she's a woman. He could see that she had breasts. He could identify other characteristics that would be inconsistent with Mary being anything other than a woman. But you know what? Dr. Bob is pretty angry at being sued, and so he wants to deny everything. He wants to say, well, I don't know that she's a woman. I mean, I saw that she had breasts, but hey, a man can have plastic surgery and have a breast augmentation. So I don't know that for sure. I did not do a pelvic examination, and even if I had, plastic surgery can be very, be of such high quality that it's hard to tell even under those circumstances whether a person is genetically a man or genetically a woman. So I'm going to deny that. Well, guess what? The court's going to be troubled by that because Dr. Bob has no reason to dispute that. It would be highly unusual for somebody, I mean, it has happened in the history of the world, for somebody to maintain that they're one gender and they're in fact another gender. And Dr. Bob has no reason in this case to think that Mary is anything other than a woman. So for him to contest that fact without any basis would likely be a Rule 11 violation. Of course, if he did have a basis, then that would be a different situation. So we've looked at the types of behaviors that could be Rule 11 violations. Let's consider when there is a violation, what the court might do. So now we're going to be in the Section C of the rule, which is the sanctions section. In general, if the court determines that Rule 11b, of course this is the section that talks about what violates the rule, has been violated, the court may impose an appropriate sanction on any attorney, law firm, or party that violated the rule or is responsible for the violation. So the court can certainly sanction the party, the person suing, the plaintiff or the defendant. That's not that surprising, but this is the part that strikes fear in the hearts of the attorney in the law firm. The attorney is on the hook. The law firm is on the hook. So it's not just the party, it's a broader category of sanctions. And in fact, many times the court in Rule 11 situations may not sanction the party at all and may only sanction the attorney and or the law firm. The logic there might be, the court might say, look, you know what, the party didn't know what the attorney was doing. The party is kind of an innocent victim. The attorney was trying to be clever, to be obstructionistic by denying things that they knew to be true or making allegations that were clearly untrue. And the party may not have even known what was going on or may have not been legally sophisticated and not understood that that wasn't appropriate. So sometimes the judge may actually sanction the attorney of the law firm without sanctioning the party. It's also, though, quite common for all three to be sanctioned. And sometimes for just the party to be sanctioned. So there's the judge has a lot of flexibility in who he is going to sanction under the circumstances. Okay, a motion for sanction. If warranted, the court may award to the prevailing party the reasonable expenses, including attorney's fees, incurred for the motion. So one way that these Rule 11 violations come to the attention of the court is when the other side files a motion for sanctions. Hey, Your Honor, what Dr. Bob pleaded or how you responded to the motion is a Rule 11 sanction. You ought to sanction Dr. Bob and or Dr. Bob's attorneys. Or maybe it's Dr. Bob complaining about Mary and Mary's attorneys. That is one way that this comes to the attention of the court. And if the court agrees with the person or the side filing the motion, then he can, of course, sanction the other side. And he also has the ability to reward, in some sense, or award, maybe is a better word, the prevailing party, the one who filed the motion, with the costs associated with filing the motion. So, you know, obviously it takes some time, maybe 2 or 3, 4, 5, 6 hours, whatever the amount of time is, to write up the motion, to write up the brief, to do the oral argument. All of those tasks, if the court finds that the motion was appropriate, the court can, but doesn't have to. You see, it's the word may. So may means it's permissible but not required. Can say to the side that he's sanctioning, hey, not only do you have to handle this sanction that I'm giving you, but you're also going to pay the other side its costs of bringing this motion. And so the attorney on the other side charges $400 an hour, and it took him 6 hours to prepare the motion, the brief, and for the hearing. And so we have 6 times 400, so you need to pay the other side $2,400. That would be an example of how that might proceed. It's not unusual for there to be sanction motions, especially when there's a disagreement between the parties. In fact, it's not unusual for one side, if they disagree with what the other side is doing, is to file a motion, say, to compel, which is a motion that is filed with the court saying, Your Honor, compel, force, require the other side to do X, which is what they should be doing anyway, but just make them do it now. And then many times they will include in that motion and a motion for sanction. So it might read, motion to compel the production of certain documents and motion for sanctions. And so the judge will then have to rule on both. Is he going to compel? If he doesn't compel, he's not going to award sanctions, obviously. But if he does compel, then he'll have to decide, is the offense that the other side did so severe or so serious that it also merits awarding sanctions. Let's go to the next slide. So one way, we're here in C2. Now we're going to move to C3. We talked about one path that the Rule 11 issue could be raised, which is when the other side brings it to the court's attention. Sometimes, though, the other side doesn't bring the issue. They might not bring the issue because they're concerned about kind of escalation. Because if you bring up Rule 11 motions all the time, then the other side is likely to do the same thing, and it can really make the litigation environment pretty toxic. And then there's always the concern that if you start falling in against the other side, the judge is going to be kind of looking at your own behavior very, very carefully to make sure you're not doing any Rule 11 sanctions. And so a fair number of attorneys are cautious about advancing that. So even if the other side hasn't raised Rule 11 as an issue, the court on its own can say, you know what? We are concerned about Rule 11. We think that there may be a violation under these circumstances. So here we have the court acting. On its own, the court may order an attorney, law firm, or party to show cause why conduct specifically described in the order, that would be in the show cause order, has not violated Rule 11. And again, show cause means to show good reason, to explain why you did what you did, that there's a good reason that you aren't in violation of Rule 11. Basically, it's saying, hey, Dr. Bob, or hey, Mary, this looks suspicious to me. I don't think you have a reasonable basis for what you've done here, but you're going to have an opportunity to set me straight. Maybe there's something I'm missing here. So you tell me why you are permitted to do what you have done, and I'll listen to you. You're going to have to show cause. And if you can't show cause, you may well get sanctioned. So here's a little definition of a show cause order. When you see the word order, think of it as a court order. This is something that the court is ordering. So the court in this situation is saying, I am ordering you, a party to the lawsuit, to show cause, to explain why you did what you did. A show cause order is a court order requiring a party to appear before the court, in other words, there's a hearing, and present the reasons why the court should not take a specified action against the party. Obviously, you never like to see it, to have a show cause order. It means that the court is angry at you and is disposed to do something that's not going to be too happy. You may be worried about sanctions. You may be worried about your relationship with your client, because obviously your client is not going to be too happy about this. But keep in mind, even if you dodge sanctions or you aren't too upset about the amount of sanctions, you're going to still be facing this same judge for the rest of the case. And so if he doesn't think very highly of your lawyering skills and your ethics, it's going to be a pretty uncomfortable time in this particular court. So it has implications beyond just what that ruling might be in that particular part of the case. Let's go to the next slide. Now we're going to talk about planning the investigation. So we've talked about why we need the investigation. We need the investigation for partially because we want to avoid any Rule 11 problems. There are other reasons that we want to engage in the pre-lawsuit investigation, but certainly Rule 11 is a big one. We'll see some more as we go forward. So let's think about planning the investigation. We're going to have a list of things that we're going to want to think about pretty systematically before we file our lawsuit, again, for the plaintiff or before we file our answer for the defendant. So let's look at some of those things that we're going to be thinking about. One is we're going to want to ascertain each element of our client's cause of action that the client must prove it at trial. If for the defendant, of course, we're going to ascertain the elements of the other guy's cause of action and what the other guy must prove at trial. And if we are the defendant, we may want to think about advancing certain affirmative defenses that we might have. We wouldn't have a cause of action under those circumstances unless we're going to file a counterclaim. But under those circumstances, if we feel that we have an affirmative defense or some other response to the lawsuit, then we want to identify the elements of those affirmative defenses and what we're going to have to prove in support of that. So it's a little broader than just cause of action, but for the sake, since we haven't kind of gotten down into the weeds yet about all the different parts, let's just think of it in rather simple terms and think of it as a cause of action. Then we're going to want to organize the evidence based upon those elements. So we're going to want to group all the apples together and all the bananas together and all the oranges together. When we have the elements, we'll have a kind of a checklist, kind of like we were talking about with negligence. Duty of care, breach of the duty, proximate cause, damages. So we have 4 buckets, and so we're going to sort our evidence into those 4 buckets. It might be that a given piece of evidence fits into more than one bucket. Okay, that's fine. That's not to be unexpected, but we'll want to have something in every single one of those buckets. And if we can't find something to fit in it, we're going to want to have it come up with a strategy for that. So we're going to want to arrange, categorize, sort the evidence. We're going to want to identify where we are going to get all this evidence if we don't already have it. Some of the evidence that we're going to know about or think exists are going to help us. They're going to support our case, but there's probably going to be some facts that aren't going to help us. I mean, after all, if all the facts were in our favor, probably we'd just be able to persuade the other side to settle right now because they're going to lose anyway, right? So it's pretty rare that everything is to our advantage and nothing is to our disadvantage. And you may be tempted to just look at the good facts. After all, everyone likes good news, right? But if we avoid the bad facts, avoid the bad news, we're actually doing our client a disservice because obviously the jury's not going to avoid the bad facts. We need to prepare for those facts, and by knowing about them, we can come up with a counter argument or a way to diminish the importance of that. So these are our first three steps that we want to think about. Let's go on and look at some more facts or more steps. We also want to ascertain which sources to examine now before the actual lawsuit begins. We would call this the informal stage, and which facts we'll want to take care of during the discovery process. Generally, informal discovery is better because it's less expensive and it's going to be closer in time to the actual event, so in many respects it's going to be more reliable. And it's also stuff that sometimes we can keep confidential from the other side. Obviously, informal discovery, everyone's going to know about everything that we're sharing. So there are some strategic advantages for doing it informally. But the reality is there's going to be some things that we're just not going to be able to find out until we're in the formal discovery process. So definitely we're going to have things in both categories. Let's look at number 5. Ascertain the best methods to obtain the facts from the sources. And this is kind of drilling down a little bit more into category number 4. So, in category number 4, we're going to have sorted it into informal investigation, formal discovery. But we're going to want to drill down more. Okay, if we've decided this is an item that we're going to find out through informal investigation, well, how are we going to go about doing it? Are we going to interview Mary to find that out, or Sally to find that out, or Teresa to find that out? Let's come up with a plan for how we might go about getting that information. If we're going to use formal discovery methods, well, how? Which one of the many discovery tools we have? Are we going to depose somebody to get that information? And who do we think might be the person to depose? Of course, there may be multiple ways we're going to find this information out, and we may not actually know the exact person we're going to depose. So we're not necessarily going to have all the answers, but it's useful to start thinking about those things. And again, there may be question marks. This is what we think we're going to do, but it may not end up being what we're going to ultimately do. But at least we're making progress toward getting a complete picture. Then our last one is going to be obtain the facts that are available informally now. So we've sorted it into informal now, formal later. Then we've drilled down a little bit more and decided how we're going to get the informal, how we're going to get the more formal later on. And now that informal stuff, we're going to go ahead and obtain. We're going to do the interviews. We're going to get the public records. We're going to do whatever we need to get that stuff before we file our lawsuit. So now we're ready to drill a little bit more into each one of these 6 categories. And so let's get started on category number 1, which is elements of the cause of action. Okay, so the first thing that typically you're going to do when you get a new matter is you're going to interview the client. You're going to want to find out the facts as he or she believes them to be the case, the documents, the evidence, whatever that might be, that the client is able to share. And that's going to lead you to start developing legal theories. Now, the client, unless the client's an attorney or paralegal, isn't going to be in a position to tell you what the legal theory is. That's not going to be the way that they view the facts of the case. But you're going to be thinking, okay, this is what they're saying. How can I make that into a recoverable idea in a lawsuit? What's going to be my legal theory? And usually you're going to have more than one legal theory. I don't say usually, but very commonly you'll have more than one legal theory. And you may want to test out several different legal theories and then see if the facts are supportive of it. And again, at this point, you don't know all the facts. And even the facts you think you know from your client may not end up being true. Maybe your client's mistaken. Maybe your client's lying to you. So you're going to have imperfect knowledge at this time, but it's good to start kind of testing out theories, thinking about the ones that might work. As you kind of interview the client and then go maybe think about the legal theories or do some legal research to ascertain more of the legal theories, you're very likely to find out, oh, I didn't know I should ask my client about that particular issue. And so there's likely to be almost like this feedback loop that you're going to talk to the client, do some more research, find out some more questions you have for the client, and kind of keep on looping back. Ideally, you don't want to go back and kind of one more question to the client, again and again, but sometimes it's necessary. And of course, if that's what's necessary, it's what you ought to do. On the other hand, you may want to anticipate some questions. You may want to do a little bit more research so you have a list of things that you want to talk to the client about. Let's go to the next slide and learn more about the elements of the cause of action. So where are you supposed to do this legal research? Where are you supposed to find out the elements? Well, there's lots of different ways of doing it. I'll be honest with you, a very common way would be just to talk to the attorney. Hey, attorney, what do you think the theory of our case ought to be? Very likely he or she will have some ideas, so that's a smart strategy. Another very common strategy would be, this is going to apply to many law firms, is that law firms, especially on the plaintiff side, specialize in very discrete areas. They do car accident cases. They do medical malpractice. And so they have certain legal theories that they are using very, very commonly. And if you're a paralegal in the office, you probably are very familiar with what needs to be proved in those type of cases. So if you do medical malpractice, med mal as it's oftentimes called, you're going to know exactly those theories. You may not have any idea what the elements, say, of a defamation claim are, but you know about medical malpractice. And so you will kind of almost have that research pre-packaged. You can maybe even go to another litigation file and pull that information. But let's say your law firm is stepping out of its usual practice area, or it's a very diverse practice to begin with, and so you're constantly going into new areas. Well, a smart place to look is in the pattern jury instructions. Now, that may sound kind of silly. Well, gosh, we're so far away from a jury. I mean, we haven't even filed our lawsuit yet. That's going to be years down the road. Why would we want to look at pattern jury charges? And by the way, a jury charge is just jury instructions. The charge, we call it a jury charge because this is the charge or the instruction or the order, so to speak, that the judge gives to the jury in telling the jury how to think about the decision that it needs to make about the case. In other words, it's telling the jury what the law is in this area. Because the jury, of course, doesn't make the law. The jury just applies the law that it is given from the judge to the facts of the case. The jury decides what happens, and then once it's decided what happens, then it looks at the law and sees if there's a fit between the law and what the fact pattern is. So let me give you a little history about pattern jury instructions. Once upon a time, whenever there was a case, before there were pattern jury instructions, the two attorneys from the two sides would propose jury instructions to the court. And of course, the plaintiff would propose very pro-plaintiff jury instructions, and the defense would propose very pro-defense jury instructions. And then the judge would have to decide how to take those, either to completely take the plaintiffs or completely take the defendants, or to mesh the two together, or to substantially rewrite them. No matter what the the judge decided, those would be presented to the jury. Well, getting jury instructions wrong is one of the most common areas for appellate courts to reverse and to overrule whatever happened in the jury deliberations. Because if the jury if the law was not explained correctly to the jury, then the jury probably didn't get the verdict right. And so this was an area kind of great peril to judges. Judges don't want to be reversed. That's embarrassing. And so they wanted to make sure that they were having good jury instructions, but every single case they were having to kind of go through this battle of one side wanting really favorable, the other side wanting really favorable to them, and how do they come up with something that's kind of middle of the road. Well, then bar associations started thinking, hey, you know what? I mean, why have each judge reinvent the wheel every time? There are certain situations that come up all the time. For example, I mean, how many car accident cases get litigated every year? Well, in most of those cases, there is, um, you know, uh, a great deal of similarity in the types of things that have to be proven. And so why don't we just have standard instructions? And certainly there are going to be unusual facts in some cases which are going to require either additional jury instructions or some minor tweaking of the jury instructions, but at least this is a good starting point. And this is because they have been approved. The court is not going to have to be nearly as concerned about getting reversed. Well, as you can see, the judges would like that. It saves them a lot of effort, and it also reduces the chances of them being reversed on appeal. Another issue with pattern jury charges is, of course, juries are made up of lay people. They don't have any particular legal training. And so you want to have jury instructions that are legally accurate, but are also written in such a way that the members of the jury are not going to have a difficulty applying the standards in those particular rules. Well, we all know that understanding legal writing can be challenging under the best of circumstances. So you really were asking the judge to do two things: accurately describe the law and describe it in a way that a layperson can easily understand and apply it. Those are pretty hard two things to do. And so the pattern jury charges are attempting to do both of those things. As I said, this is done on a state-by-state basis because almost all law is state-driven law. You may be thinking to yourself, well, state-driven law? Why are you talking about state-driven law? We're in the federal court for this particular class, so shouldn't we be looking at the federal law in order to determine what the elements are? Well, not really, because a large portion of the lawsuits that get filed in federal court are filed based upon diversity. If you're not familiar with diversity yet, don't worry, we'll talk more about it. But those of y'all that are familiar with it, let me kind of speak to you for a second. Diversity, of course, is when you file the lawsuit or the court has jurisdiction because there are parties from two different states who have that dispute with each other, and the amount of controversy is over $75,000. In that scenario, what the plaintiff is suing about isn't center stage. Usually in those cases, what the plaintiff is suing about is a state law claim, a claim that would ordinarily be filed in federal court, but for the existence of diversity of citizenship. So, as a result, for a pretty significant portion of federal cases, you're going to have the law that's actually being applied, the substantive law, is going to be state law. Of course, the procedural law is going to be federal law because you're in federal court, but the substantive law may well be Texas state law. Now, of course, there are federal bases for lawsuits. There are federal statutes, for example, that result in cases being filed in federal court. And so you do have pattern jury charges for those types of federal claims as well. But you'll see both used in federal court. Now, you may be thinking, gosh, that must be hard for the judge. Not really, because keep in mind that the federal courts are in a particular state. The judges that are over those particular courts practiced in that state almost always before they became judges. So if you were to appear in front of a federal judge in Texas, obviously he's a federal judge now, but very likely he practiced or she practiced for many years in Texas state courts and is an attorney licensed to practice in those state courts. And so he or she likely has a very sophisticated understanding of Texas state law as well as federal law. So these are handy dandy tools to look at. They, again, present the law in very simple terms and in very accurate terms. And so this can be a good way of you finding the elements early on in the progress of a case so that you can decide, what do we need to prove? If we're the plaintiff and if you're the defendant, what does the other side need to prove? Of course, as I said, pattern jury instructions exist for the most common types of allegations. Your case may be different, and so there may not be a pattern jury charge that's a really good fit. In that case, you're likely to want to go to case law or a statute. And many times when you look at the case law or statutes, they will break it down and say, Plaintiff needs to prove these things, and you can actually kind of see bullet 1, bullet 2, bullet 3, bullet 4. So even when there aren't pattern jury charges, if you look at the relevant sources, you're going to oftentimes find those elements. If you can't, I certainly encourage you to talk with the attorney to get some idea about where he or she would recommend that you look. Okay, so now this is the example I was talking about before, the elements of negligence. And here we have 4. For those of y'all that have taken torts already, by the way, torts is LGLA 2303, one of the required courses for both the certificate and the Associate of Applied Science in Paralegal Studies, you will already know what the definition or the elements of a negligence tort is. But here we have them. The defendant owed plaintiff a duty of care. The defendant breached that duty of care. The defendant's breach proximately caused the plaintiff's injuries. Okay, these are the 4 things that the plaintiff has to prove to be successful. Now, the plaintiff, the paralegal supporting the plaintiff, could have found the elements of the common law negligence, which, by the way, would be a state law thing. You could have found it in the Texas pattern jury charges. You could have found it very likely in case law. You wouldn't find it in a statute, but you could also find it, say, in a legal encyclopedia, such as Texture. Lots of different places to find it. You could also find it in a treatise. I'm sure you could probably find it in Dorsanios as well. So we found the 4 elements. We feel that we know what's going on with our 4 elements. And so now we're going to look at the Texas pattern jury charge and see how that relates. And this is actual language from the pattern jury charges in Texas. This kind of gives you a flavor as to what the jury is ultimately going to hear in the case, right? Okay. So negligence means failure to use ordinary care. Ordinary care means that degree of care that would be used by a person of ordinary prudence under the same or similar circumstances. Okay, so let's flip back here. We know we have 4 things to prove. The first thing we have to prove is defendant owed plaintiff a legal duty of care. Okay, so this is what ordinary care, that's what the duty is, and this is the definition of that duty. So this is giving you information about this first element. It's giving you the language that you need to know for that first element. So this is an example of how you can use the Texas pattern jury charge to actually start constructing an understanding of what the elements are for your particular case. Let's go to the next slide. The next slide is going to address the issue of causation. Let's go back to our list here. We're going, I'm sorry, I think I hit the wrong button here. We're going to skip over 2 and go to 3. The reason that we're not having any kind of a pattern jury charge on this one is that this is all facts. Well, what did defendant do? Obviously, every single case is going to have a different set of facts. In some cases, the defendant breached the duty by driving over the speed limit, by not paying attention, by being intoxicated. You know, there's lots of different ways that negligence can happen. And so you're not going to get a jury instruction on this one. So you're going to get one on the first one. You're going to get one on the third and on the fourth. So we're talking about this one right here. Defendant's breach proximately caused. Let's pause here and look at the word proximately. This is not a word that most of us use on a regular basis, at least outside of the law. And so let's look at that a little bit more carefully on this slide that we're looking at here. Proximate cause. There's a definition here. And again, this is the definition that the jury will hear, most likely. Proximate cause means a cause that was a substantial factor in bringing about an event, and without which cause such event would not have occurred. In order to be a proximate cause, the act or omission complained of must be such that a person using ordinary care, again we're seeing these words again, would have foreseen that the event or some similar event might reasonably result therefrom. So we have to have, and there's 2 components to causation. We have cause and fact, which is substantial factor, and we have foreseeability, which is the second one. And you can see that in this definition, we're addressing both of them. So let's just consider for a second an example. Let's go back to our story of Bob and Mary driving around the town. They're both in cars. Bob owes Mary a duty of reasonable care. Mary owes Bob a duty of reasonable care. Bob runs a red light. Because he runs this red light, he is farther down the road than he should have been. He should have stopped that red light, and so if he had stopped, he would, be about 2 minutes delayed in his progress in the traffic. And because he is 2 minutes ahead of where he, quote unquote, ought to be, he is parked next to Mary when they leave the next light. And so when Mary swerves her car into the space that Bob's car is at, she hits Mary's. She hits Bob's car, causing injury to the car. So let's go back and look at how that might play out here on our facts. Okay, we've established that Bob owed Mary a legal duty of care. We've established that Bob breached his duty of care by running the red light. We've established that Mary was injured because her car was damaged. Maybe she was actually injured in the car accident. But the problem that Mary is going to have is that Bob's breach, his decision to run that red light 5 minutes ago, didn't proximately cause Mary's injuries, according to this definition. Really, I would say it would probably miss both of these, but certainly it misses the second one. Was Bob's decision to run the red light and therefore be 2 minutes ahead in traffic, was that a substantial factor in bringing about the event? Well, probably not, because if Bob hadn't been at that particular location, there probably would have been, excuse me, another car there. Maybe Harry's car. Maybe Harry was the car right directly behind Bob. Well, Harry never ran a red light. And so if Bob hadn't been there, well, obviously Harry would have pulled forward and would have been next to Mary. So when Mary swerved, she would have hit Harry's car. Well, I mean, really, what car Mary hits isn't really going to affect her degree of injury. And so I think a pretty good argument could be made that even though Bob breached his duty, his breach is not a cause in fact for Mary's injuries. Any car would have caused the injury. But I think there would also be a problem with foreseeability. When Bob ran the red light, it was foreseeable that he would cause a car accident at that red light. But would it have been foreseeable that he would have caused, but by running one red light, he would have caused another accident 5 minutes down the road? That doesn't seem as foreseeable to me. And so I think you'd have a pretty good argument, or Bob would have a pretty good argument, that Mary would not have satisfied the third element of the proximate causation. We're doing a fairly deep dive, I realize, into tort law, and some of this you may be thinking, I'm not getting this. This is over my head. I haven't taken torts yet. Don't worry if some of this isn't gelling. I'm just going through an example to show you how these terms fit. If you're getting the gist of it but not the details, you're doing fine. What I'm just trying to show you is we find the elements and then we look for instructions that help us understand those elements. And then we have that last element. Let me flip back here so we can see it. We've talked about this first one. We've looked at the legal duty of care. We decided this one we're not going to have instruction because it's all facts relating to the case. Then we've talked about proximate causation, and now we're ready for our last element, which is the injury that the plaintiff, in this case Mary, received as a direct result of the breach. And again, we're still in those jury instructions, and here are some examples of damages that might have occurred to Mary. So she might have pain, physical pain, and mental anguish that she's experienced in the past. But just because she experienced past doesn't mean that she won't have it in the future. Pain might be lifelong pain. She might have lost earnings in the past. She had to take off time from work in order to be in the hospital and recuperate. She may continue to lose earnings because now she is paralyzed and she's not able to be gainfully employed because of her medical circumstances. And they go on. She's had disfigurement in the past. She has some bad scars, and the scars will continue. Plastic surgery, for whatever reason, can't resolve those scars. She has a physical impairment, again, being in the wheelchair perhaps in the past, and she's also going to continue to be in the wheelchair in the future. Those are examples of the type of injuries that she could sustain. And again, we have medical care expenses in the past and medical care expenses in the future. Oops. And of course, there could be other non-personal expenses, such as the car damage, other things that might have been damaged in her car. So we're through that first hurdle, that first we had the 6 items that we were going to go through in our pre-suit investigation plan, and we've accomplished the first one. We found the elements, all the elements that we have for the cause of action, and we've kind of broken it down. We have a good understanding of what we're going to need to prove in order to advance all 4 of those elements, or it might be 5 or 3 or 7 or whatever, depending upon the particular theory that we have. So now we're going to go forward into item number 2, and we're going to prepare that litigation chart based upon these elements. So let's consider that topic. Okay. So we're going to divide it up. So we're going to have in our litigation chart a category for each one of those elements. And we're going to have for each one of those elements, we're going to want to list the evidence that we have that supports that element. We're also going to talk about, well, where do we get that from and how we're going to get it into trial. Let's look at how that might appear. So we have that duty. So we'd add here all of the facts that we have to support that duty. We talk about the source. This might be client's testimony. We talk about how we get it at trial. Well, we'd call the client to trial. Or there might be a public record we'd use. Well, how would we get that into trial? Well, we'd have to call a witness who could testify to that particular public record. We might call the defendant to be a witness in that case. So we'd have to call him as a witness at trial. So we'd have to plan that out, at least have some ideas. Now, of course, this is very subject to change. This is just kind of what our thinking is at this point, and it helps us see where our holes are, where we need to do some more work. We might reach one of these and say, I'm not sure how we'll prove this. Okay, well then you may want to go to the attorney and do some more brainstorming about how we might accomplish that particular goal. Okay, so we're done with item number 2. We're ready for item number 3. Identify all the sources of facts that would either prove or disprove each element. So now we're going to start filling in the blanks in this chart. As I said before, we've set up the chart, now we're putting in the blanks. And again, some of the blanks will be easy to fill. Some of the blanks we might say, oh, we can't really fill this one in now because we don't have the opportunity to use formal discovery. But we might have some ideas about the type of stuff that would go in there. So here are some places that you might go to find that evidence. Obviously, you might go to the client. Hey, what do you know about this? We might, and even if the client doesn't know, the client may have some ideas as to other sources of information. He might say, well, I think the defendant has a file on this, or I don't know about that, but my doctor does know about that, or I don't know about that, but my wife might, or my husband might know about that. Or I think the police have a file on that. And so the client may be able to point you to other resources. You may also think about, well, maybe the opposing party might have that information. Going back to the second scenario we had where Dr. Bob performed the surgery on Mary, and Mary was asleep, but she thinks something went awry during the surgery. Well, very likely Dr. Bob might have some testimony or evidence about that, and even perhaps more likely the hospital may have evidence about that. Maybe other people who are in the surgical theater might as well. Nurses, surgery techs, other doctors, other personnel in the surgery theater might have that type of information. And then, of course, exhibits that you create, exhibits that may already exist, exhibits that you may hire somebody to create. Then lay witnesses, again, people that have some involvement in this situation, and then people that you might hire, expert witnesses who will be able to testify. Again, going back to Mary's lawsuit against Dr. Bob, you may call a doctor to examine Mary who might say, well, I think that a sponge was left inside Mary, and that's why she's having all these problems. Well, obviously, you would need to have an expert. A lay witness isn't really going to work in that context because the lay witness would not be qualified to ascertain that information. But another doctor would be in a position to figure that part out. So we've accomplished the third task. We're ready for the fourth task. ascertain which sources to examine now informally, in other words, before discovery, and which sources to gather later in formal discovery. So we're going to consider our timing thing. Again, if we can do it now, that's better. It's cheaper, it's quicker. It's a better plan, but some things we won't be able to find now. And so we'll say, we'll be able to get it when we need to get it. Now we're ready for number 5. Ascertain the best methods to obtain the facts from the sources. So we've put them into the 2 buckets, the informal bucket and the formal bucket, but now we're going to have sub-buckets within those buckets. And so let's look at what that might look like. Okay, so if we're going to do the informal investigation, well, are we going to get it from the client? Is it what the client is going to testify to? Is it some kind of paper trail or data trail that the client might have access to? Is it going to be public records, for example, the police report, the mayor's certificate, the vehicle registration information? Who are we going to talk to? Again, a lay witness, of course, they would have to be cooperative. Many times what we call in the law the friendly witness, because we can't force a witness to come meet with us if the witness doesn't want to during the informal part of the investigation. And then, of course, an expert that we hire. I would say, well, let's go to the next slide. Then, of course, we have the formal discovery process. And this is a bit of a moving target. I mean, we're not going to know exactly where we're going to find everything out before we started the discovery process. Some of the early discovery tools that we're going to use are going to help us figure out who the right person to depose is to get this type of information. But for some of the issues, we might have some ideas, and even if we're not 100% sure, or even if we end up changing some of them, at least we've started thinking about that process. And here we have the different types of discovery tools that we might have. The one that we have missing from this list would be medical or physical examinations, but that wouldn't be from the opposing party. That would or if we were the defendant, I guess it would be from the opposing party. And then here are some other tools that we'd have: deposition testimony from uncooperative or hostile witnesses. And then, of course, the expert from the other side. We're going to get his information or her information as well. And so now we're ready for our last item in the plan, and that is, now that we've figured out what we need to find out, we figured out the particular facts we need, and we've figured out when and how we're going to collect them, let's go ahead and get the ones that we can get now and put it in our table. So let's go ahead and interview the client. Let's go ahead and get those exhibits and those documents. Let's interview those cooperative witnesses. If we've decided to go ahead and hire an expert witness, let's go ahead and get that expert witness hired and get his or her reports. So at this point, we have completed our steps of that pretrial investigation. And that means that we've gone through the steps. Now we're going to drill down and talk a little bit more about techniques that we're going to use as we go into, say, the client interview. I'm going to go ahead and end this particular lecture, and we'll start up on the next section with client interviews during our next lecture. Thanks for your attention.